Hi, everyone. Welcome to the webinar. Let's just wait a few more minutes for more people to join. While we're waiting, let me give a quick introduction. For those who don't already know us, Darrow is an AI research lab for the legal ecosystem. We study how legal exposure emerge and transform fragmented signals into legal intelligence, enabling us to create tools used by law firms, insurers, and compliance teams to detect emerging risks. Okay, I think we're ready to begin. Welcome to our webinar on plan dominance in the ERISA space. I'm Michael Harary, Director of Litigation Partnerships. Prior to Darrow, I practiced in both the private and public sector for over 10 years. Darrow really enables both the economic efficiencies and sophistication of the private sector with the justice and vision of the public sector. Joining me is Jake Hirsch. Take a moment to introduce yourself.
Hey, Michael. Great to be here with you. And hi, everyone. Thank you for joining. As Michael said, I'm Jake. My background is in litigation. I was a general commercial litigator and labor and employment litigator over the course of about 5 years in the U.S. market. And now I'm here in Tel Aviv, working as legal intelligence quality counsel, ensuring that Darrow's cases are market ready and helping to validate new legal theories that we ideate and come up with on a regular basis. Really excited to be here to talk to you about ERISA and in particular these burgeoning trends in the health plan space.
Awesome. I want to hone in on the excitement. I think traditionally ERISA has not had that flavor to it, but I think the more, and it's true, I think the more the legal landscape is changing, and I think we'll talk about it specifically here, we've noticed that ERISA is an emerging trend, both because it affects people's pockets in their 401ks, but more importantly now, and I think the next shift is because it affects their healthcare as well. So today I think we should focus more on the ERISA litigation, how the fiduciary principles, the classic principles that have been used in traditional ERISA litigation, I mean the retirement space, the traditional 401k fees, the investment menus, that type of area, and how it's now being extended into the healthcare context. And I think specifically there are two developments to focus on. First, the wave of PBMs, the pharmacy benefit managers, and how that's affecting healthcare cost litigation. Second, a newer trend, the dominant plan option theory. Jake, let's start with the first one.
Yeah, I mean, first of all, with regard to the excitement, I can't tell if it's just getting to talk about ERISA or if it's being able to do it with you. But in either case, I agree with you wholeheartedly. This is real stakes, real people, and their money. So, regardless of excitement, it's super important. Just to hone in on the first category you mentioned with this PBM litigation, just to give, for those who might be less familiar, a high level sense of what we're talking about here. As you mentioned, this is litigation focused around the dynamics for pharmacy benefit managers, which in simple terms essentially play a middleman role in the healthcare space between large generic manufacturers and distributors and the end user health plans and patients who actually need the medication. This has gotten particular notoriety in mainstream media in recent months because of our everyone's favorite Shark Tank guru, Mark Cuban, and his company, who's attempted to kind of put a spotlight on this alleged inequity, where essentially these PBMs are alleged to be essentially charging inflated prices and essentially passing those additional costs, unjustified costs for these prescription drugs onto plans and consumers, where and doing so in a dynamic where at least plaintiffs are arguing that the fiduciaries, the plan fiduciaries who are negotiating with these PBMs should be exercising more bargaining leverage to reduce those costs for their participants and are not doing so allegedly in violation of ERISA.
Yeah, I think it speaks to the fiduciary duty they have with respect to controlling those prescription drug costs. And I think in that same way, the same way they have a duty to monitor investment options traditionally in the 401ks, exactly what you're saying. I think it's the same duty they have now in terms of monitoring prescription drug costs.
I think the barrier and the sort of difficulties that plaintiffs' counsel have run into in this space is not a question of kind of the underlying merits theory of breach of fiduciary duty. It's actually more standing and redressability concerns. I think people are, if you have been following the area, are probably aware of the Lewandowski case, which was the court actually dismissed the complaint in significant part because it found that the named plaintiff actually didn't suffer a redressable harm. In other words, whether or not the individual plaintiff may have paid more for their prescription drugs, they, in all cases, would have hit their out of pocket maximum. And so those additional expenses were technically borne by the insurer. And so any damages would essentially have to be rerouted to the insurer. And so there really is no cognizable harm. And so you run into those sort of standing and redressability issues in that space. But I think the jury is not out yet completely on where that's going. And I think plaintiff counsel are starting to get creative with their framing and their plaintiff selection to kind of circumvent those issues. And we'll see how it plays out.
Interesting. Yeah, it seems like it's more of a standing court system type of issue that we'll run into as opposed to more of a legal merits issue.
Yeah, I think that that's absolutely right. And again, I think one thing, and we'll get into this more as we talk about, other types of emerging trends. One thing about these other emerging trends is they're kind of like simplified and contained in a limited universe. Again, we'll talk more about that later. But in the PBM context, it's a really attenuated causation argument here. You have, hypothetical bargaining leverage that a fiduciary is supposed to be leveraging against a PBM. Then you have sort of like what would have happened if they had exercised that bargaining leverage and where that money would have flowed through. It's just very attenuated. And I'm not saying it's impossible to overcome that causation narrative issue, but it's just a little bit messier. And so I think you've hit the nail on the head. It's very much structural as opposed to like the underlying breach theory.
Interesting. I want to shift, towards the second topic where I think the next wave of health plan litigation with respect to ERISA is, and that's dominant plan options. I have my theories on it, but I'd love to hear your thoughts first.
Yeah, maybe it just makes sense to start with like a general overview of like what the theory entails. I know you know it, but maybe for our listeners, just a little bit of an introduction would be helpful. Essentially, side by side within an overarching welfare benefit plan offered by an employer, if one of them is going to cost more, then you would expect, as a reasonable person, to have some sort of benefit or trade-off for paying more. But in our sort of theory, not our theory, but in the prevailing theory now, we're seeing that even though there might be a more expensive option, where there's actually no corresponding trade-off. And so participants are incurring additional costs for no reason. And from like the fiduciary breach perspective that you were, correctly highlighting before, plaintiff's argument is, well, as a fiduciary, you shouldn't be putting this like inquiry on me, the participant. I shouldn't need to sort of like go through the math to figure out if a plan is dominated. If it's dominated, it shouldn't be in the plan in the first place.
Yeah.
So, yeah, I mean, I don't know if you have anything to add, but that's sort of how I see it at a high level.
No, the way I always look at it is that you're exactly right. The fiduciary has the duty, and he breaches that duty by offering a plan option that's economically worse to another option. In other words, when you have a plan option that is almost always more expensive participants, under reasonable scenarios, well, then it's going to be dominated, and it's imprudent to offer that.
Yeah, and I think, implicit in sort of our characterization of this theory, we are making kind of one big assumption here. And we've seen that kind of play out in the initial lawsuits that have been filed in the court system. And so people may be familiar with this Barbich v. Northwestern case. It's sort of like the first case to reach a dispositive motion stage and have a ruling on that dispositive motion in the entire United States. And essentially, what we've been kind of assuming is that there is a fiduciary duty that applies to these plan sponsors and administrators, these big employers. I guess what I'm focused on here is that Essentially, this is the first decision that we've seen a court actually weigh in on like how they're going to approach whether or not a fiduciary duty applies. Obviously, the employers are saying we're acting in a settler capacity. We're simply creating the construct of the plan in which participants operate. We're not exercising any discretion. Plaintiffs are arguing, no, maybe you're acting as a settler by setting up the plan in a particular way, but by setting premiums and communicating with us about our rights and the nature of our benefits that we're entitled to, you're exercising discretion and acting in a fiduciary capacity. And what we've seen, you and I are kind of taking it for granted again, but we've seen that the court is kind of agreeing. It's saying whether or not you're a fiduciary is a fact-intensive inquiry that we're not going to get into at the motion to dismiss stage. So let's take a little bit of discovery. Let's see what's actually going on under the hood. And for all intents and purposes, this is a positive initial indication for plaintiffs' counsel, because if you have, it's suggesting that if you have a well-pleaded complaint and reasonable factual allegations that point to domination that's supported by the underlying math and modeling, then there's a good shot you're going to get some discovery.
Yeah, and I think just taking a step back, just to reframe where we are, it's the two plans. One has a higher premium and a lower deductible. The lower has a lower premium and a higher deductible, and that was the structure in the Northwestern case, correct?
That is correct. Yes.
And maybe you want to just talk about how those plans interact with each other.
Yeah, I mean, what I can say is that, like, in the end of the day, this stuff is complicated. I mean, it is not easy. And so, you mentioned deductibles, you mentioned premiums. There's
out-of-network doctor,
out-of-network, in-network, co-pays, co-insurance rates. You have prescription drug costs. You have so many different variables that, go up against each other in the different plan options. And it's really difficult for an individual to suss out whether or not a plan that they're opting into might be dominated as a technical matter. So, like, I can speak to sort of how we view that on our end, but I just want to make sure that I answer your question. Is there something specific that's interesting to you in terms of like those signals and those inputs?
No, I think that's actually right. I think it's the difficulty of finding these signals that have allowed these injustice or these actions to go undetected until now. Because exactly that point, to map out and model how you're out of your network and how your co-pays and how your benefits will be counted up to see which is better. The high deductible, the low deductible is nearly impossible until the use of AI tools that we have here at Darrow. And you'll take a moment to go further, but essentially, the ability to now use game theory and modeling, statistical modeling, to map out each scenario is what's allowing these fragmented pieces to surface.
Yeah, I think, we at Darrow, being a sort of a laboratory, really, where we're kind of experimenting in new and creative ways to identify legal exposure that already exists, but isn't necessarily in the spotlight, as you just said. And essentially, over the past few months, what we've been doing here at Darrow is we've been refining our model to really be able to take all of these different variables that we just went through, you and I, Michael, and have been able to sort of like create the laboratory conditions to understand if you factor in every plan parameter that's in play in this particular situation, are you going to have a trade-off for this more expensive option? Is there a real reason to be offering two PPO plans side by side if it's always better for a participant to opt in to one of those two? And so, that modeling process has really been quite difficult, painstaking, labor intensive, both from an AI perspective and from a brilliant human data analysis perspective. Some of the people I sit next to are pretty incredible. I could never do it in a million years, but I'm here and I'm happy to talk about it. I think what we found in sort of that baseline model is it doesn't even really tell the whole story. It might give you an initial indication when you put, like we said, premiums, deductibles, co-pays next to each other. It might give you an initial signal. There's a domination risk here, but it doesn't necessarily account for all of the other variables that we mentioned, like prescription drug costs, which can just vary from individual to individual so significantly. So what we've done here at Darrow is we actually created a second statistical computational model that actually simulates patient stories that could potentially play out. It will run 1,000 patient stories under specified plan parameters that we've come across and essentially determine, did any of these patients in this theoretical simulation ever save money by opting into the alleged dominated plan? And if the answer is no, along with the baseline model that lines up the core plan parameters side by side, if it's consistent across both models, you have a pretty good indication that there's domination and a potential breach of fiduciary duty.
Yeah, and I've seen these models. What's interesting is it doesn't only work in one respective coverage. In other words, it goes through the independent, a single person, then it goes through single plus child, and then it goes through family. So you have each scenario, based on how much you pay, and based on what tier you're in, it's able to model each one accordingly.
Yeah, no, you're right. I didn't even mention the different coverage tiers. Yeah. Every variable we just talked about also has to be funneled through the lens of a different coverage tier,
right,
like
exactly.
you said. So it's quite complex. And look, I think we have an initial signal from the Northwestern case. If you can clear that hurdle of, hard, verifiable mathematics showing domination, plausible domination under, Iqbal and Twombly from a pleading perspective, then you're going to get to see some discovery. We have other cases pending. There's another case against the University of Rochester that's sort of right behind the Northwestern case. And we're very anxious to see how that plays out. We think the initial signal is very promising for this space to kind of blow up. But as we get more and more proof of concept, we will be able to further refine our models and tweak them to make them sort of aligned with what the courts are looking for, because right now we're focused on pure domination. But is it really a fair trade-off if in 0.1% of scenarios the dominated option is better? Like, the court has yet to really engage on the merits in that way. And so as these cases continue to come out and play out, we'll start to get a better idea of how they're thinking about those issues. The one thing I would say is we mentioned this sort of like high-level initial defense that the defense counselors are putting forth, which is the settler versus fiduciary dynamic. And from Darrow's initial, indication and nationwide research that we've conducted, courts are pretty universally convinced that that question is a fact-intensive issue. And so even though it's a viable argument in theory, it's unlikely to be successful without more precedent to suggest otherwise. It's unlikely to be successful in completely defeating this theory at the outset. We feel that if you're able to locate a lead like this that's verified, you're likely to be able to apply that additional pressure, get some discovery, and see what's under the hood.
Yeah, for sure. And I think just to really double click on both the statistical analysis, but there's also a level of research into plan benefits. It's really important here, and I don't want to overlook that, is that you're not only having two different plan options that the company is offering, but that they're identical in terms of the coverage they offer. And that's really critical. So you have to do a statistical analysis. You have to run scenarios for each coverage and each plan spent. But you also have to do an in-depth analysis on just benefits that each plan is offering and ensuring that they're the same. Because it would be harm or detrimental to the argument if they're offering two different products. So the more the identical they are, the more strength it gives to the plan dominance. So there's really a twofold, or really two paths to the analysis that needs to happen. On the one hand, you have to have the healthcare analysis in terms of the benefits it's offering. On the other hand, you have that statistical analysis. And I think that's really where you have both aspects of the tools in this AI lab. And I like the way you had mentioned earlier in terms of comparing one plan to the other, because just like bring it back to moment to the classic 401k scenarios. Just like in the 401ks, you can't offer imprudent investment options, and you can't offer inferior funds. You can't keep that in your lineup. Well, it should be analogous here. You shouldn't do that in the healthcare space. You shouldn't offer a plan that's always going to be inferior to another one in that same lineup.
Yeah, and just to piggyback off of that, Michael, we talked before about the shortcomings of the PBA sort of cause of action, and there you didn't have these sort of I keep saying the word laboratory, but you keep having these you don't have laboratory conditions. You have these redressability and standing issues that you run up against. But in this space, by contrast, you're exactly right. You're comparing apples to apples. You're comparing a PPO plan to a PPO plan. They both have in-network situations. They both have out-of-network situations. They both have deductibles. They both have premiums. They both have prescription drug costs. And they both have multiple coverage tiers, as you pointed out. So I think you're absolutely right. You're getting an apples to apples one-to-one comparison, and it's a very easy to if you identify domination, which is not easy, it is quite easy to say the amount of money they paid for this in excess of the other option is direct harm to that individual. End of story.
Yeah, that's really interesting. Yeah, I think that's right. And I think what's interesting is also how these developments interact. You have the PBM litigation focusing on more of the cost structure inside of the plan. You have the dominant health litigation, which is on the structure of the plans and what they're choosing. And they really, another wave, another broader theory going forward. And that is that fiduciaries can be responsible for making sure that the healthcare is purchased efficiently and the plan options are designed in a way that makes it economic sense for its participants. So stepping back, I think we see how there is a shift and how ERISA is expanding, moving from the monitoring process and compliance to more the evaluating whether plans are structured and priced in a way that's fair to participants. And this comes also to the heart of what ERISA is. It's protecting individuals' pockets and protecting workers that are entitled to the highest of fiduciary duties. We know it's still evolving and courts haven't fully resolved it, but we see where things are going. I think we have some time for questions. Let me take a look if someone came in. Okay, first question. What signals should attorneys look for when evaluating whether a potential case is a strong candidate for this type of theory, dominant health options? You want to take this one?
Yeah, I mean, I can try. I don't know if this is an acceptable answer, but I think my gut reaction is to say, well, don't bang your head against the wall. Partner with Darrow, where you have brilliant data analysis modeling experts with particular expertise in the ERISA space, and they'll point you in the right direction. I mentioned before all that goes into this, or at least I tried to capture all the complexity in here. And the reality is it's not something as simple as, locate the deductible and it has to be over this amount. It's more than that. I'm not sure if I mentioned this before, but the one interesting thing about this, which is again similar to, as you pointed out, the imprudent investment space, is that all of this is sort of out there. You just have to know where to look. And so, what we typically like to focus on are big plans where they offer parallel PPO options. So again, you're comparing apples to apples. You're not trying to fit a PPO domination analysis into and up against an HMO, for instance. You're just trying to sort of keep it simple, where presumably many, many participants in that large workforce are funneled into an inferior option. That's sort of like how we think about it as at a high level. But I mean, Michael, you're the one on the ground talking to lawyers who are interested in these cases and looking for new ground to break. So, I mean, do you have anything to add? I mean, it seems to me like Darrow is sort of ready to deliver on value here. Do you have anything to add?
Yeah, no, I think it's what we look for are large plans, to be honest, large plans with many participants. So on the one hand, you have higher damages off the bat, but you also have the ability to model and run different scenarios, and it allows you to find that dominance. So in these larger plans that offer similar benefits coverage, we then can take a look at what they're offering. There's availability of data, and then there's availability of different types of scenarios to model. And the more you see that, I think it's more impressive to a court to see, even though you may assume this huge, vast number of people will have such vast different options and different outcomes. So eventually you will have one overlapping and it won't be completely dominant. And even in those cases, you still have this dominant coverage, this dominant plan option. And I think that goes a long way in the courts.
Yeah, I couldn't agree more.
Okay, second question came in. Are there particular types of plans or industries where these issues are more likely to arise?
I look, I think you kind of hit on this at the
Yeah.
start a little bit. Like, in the end of the day, this has gotten to a point where it's simply systemic. There, whether it's intentional or not is sort of irrelevant. The big plans out there have allowed this space to develop in a way where they're either turning a blind eye or allowing, otherwise allowing these dynamics to persist.
Well, I'll say this. I think it's kind of what we piggyback on the first question is that I think that plans and industries are the larger plans that have many participants because I think you'll see these issues arise, A, when you have a lot of different potential scenarios. So you'll show dominance across various scenarios that are unique to each other. If you have one single type of individual, one type of employee, well, it's harder to show this real dominance across a large offering because it's one unique situation. But if you have many different unique situations, well, and yet it's still dominating, it gives a lot more strength, I think, and credibility to say there's a dominant plan option here, and it's at the fault or a breach of duty on behalf of the practitioners.
Yeah, and I think at Darrow, we're, on a very simplistic level, we're trying to shine light onto,
Yeah,
you know, harms that are taking place that affect real people. And let's face it, bigger plans, not only does that come with bigger damages, excuse
yeah,
me, but it comes with more harm. You're affecting people on a very, wide basis across different socioeconomic statuses and different life experiences. And so, yeah, I would agree that plan size is a huge thing. Um, Industry wise, I think we already kind of touched on it. It's not really divvied up like that. It's
yeah,
more
exactly.
so, do you have the laboratory conditions where you're going to be able to put these plans side by side next to each other and really make an informed determination about whether or not there is domination?
I think that's right. I agree with that. Okay, I think that's all we have time for today. Thank you for listening and joining. We hope you found it interesting. If you're interested in working with us on health plan cases or anything else in what we do, please be in touch. Contact us at contact@darrow. You can send me an email, michaelharary@darrow.ai.